Justice Thomas?
Just so I'm clear, for you to prevail, we would have to say cause is the equivalent of INM.
No, I don't think so, Justice Thomas. I think you could really take any definition of cause that we've been sort of batting about, with the exception of General Sauer's definition, and we would prevail. I think the only, and I do think the definition that's presented to you by the President is a pretty extraordinary one, because, you know, General Sauer's a very careful lawyer. So in his briefs, he doesn't talk about mortgage fraud, he talks about apparent mortgage fraud. And when you're talking about apparent misconduct as opposed to actually found misconduct, that A, doesn't get for cause, and B, it sort of is advertisement that you have a process failure. And so the fallback then is or gross negligence. So one way to think about this is, if the standard of for cause is more demanding than gross negligence, then we certainly win. And we didn't even get a chance to sort of argue about gross negligence.
What is your, if it's not the equivalent of INM, what are some of the other standards that you would apply that would be sufficient for you to prevail?
So I think the single best reading of the statute is INM plus ineligibility as informed by Section 244 of the statute. I think then my fallback would be, then you pick up the common law, and if the common law makes you uncomfortable because of Justice Alito's hypos, you could tweak the common law. But you would then be tweaking the common law. And that's why, honestly, at the end of the day, although it's uncomfortable for a few moments to answer some of those hypos, you always have impeachment as the backstop, and we had, what was it, 90 years, plus if you go back to the Interstate Commerce Commission in 1887, almost 150 years with INM, and this didn't really pose a problem in practice.